Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're doing commentary on the case. Dahil mihi Anglican po, he's very much Latino. I didn't ask you to interrupt me.
Is that correct?
Oh, for crumb's sake.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict. I know I've been missing for a few days, but I'm back. I'm back. I've been working. I've been busy. And we get to talk about that a little bit today. It is beautiful outside. I'll tell you, it is absolutely incredible sitting up in Park City, Utah, where the 2002 Olympics were held. Sitting there in the valley, looking up on the hillside with all the ski resorts and the ski runs and the ski jumps around. Just beautiful, clear air up there. Getting to enjoy court up there in the Summit County Court complex up there on Justice Road. I thought it was an aptly named road. I think they built it just for that building. But a lot of fun today up there. Had a great time both yesterday and today. Had some hiccups with technology the first day. We're still getting everything sorted out. But here's what I have. We have the Kouri Richins trial. Now I realize I've uploaded already that to my channel. Okay, it's already there. But I have to tell you a little bit. Before we get too far, I have to find out if chat is working. And it appears to be, which is great. Let's see, which is good, because Denise, you won chat. I need to put that on the screen if you'll give me just 1 second. Wow. Can you hear that? Do you hear echo? Echo? Yep, the TV monitor volume was turned on. Okay, let's go full screen on this guy. Let's see if that works. Yes! Sample user. No, just kidding. It's not sample user. It's Denise Feldman Ersland, first in chat. Thank you very much, Denise. Congratulations. The internet's all yours today, which is good because we're going to need your help here very shortly. I'm going to play some stuff. Let me tell you, this court, every court's a little bit weird, right? Every court's weird. And I realize I owe 2 days of birthday songs. We're going to do that before we get too far. So if I can find the birthday wishes for the last 2 days all in one message, we'll sing to everybody. But here's what we've got. We have every court's different, and every judge sort of runs things a little bit. Every judge is like the king of his own courtroom, right? And so the judge decides how media gets to act in their courtroom within reason, within a scope. Whoa, look at this. Emily Baker just gifted 50 memberships. Emily, thank you very much. Thank you. Great stream, by the way. Thank you very much, Emily. One of I would say, the pillars of LawTube. If you don't know Emily D. Baker, you have not experienced the joy that is YouTube. I can put that out there. Emily, thank you. Thank you for the super generous gift. Let me tell you what... Thank you. Glad you got to use the feed, first of all. This is something that I've been working towards since we first started the channel, is getting feeds not only that we can use, that you can watch, that are high quality with good audio and everything else, but also available for some of the other amazing creators and amazing people in LawTube, as we're just LawTube adjacent, that have great insights and to share. So. We took steps further in that. I got some contacts for some remote stuff that I'm going to be using in the future for more people to get more court cases in like this, so we can make it available without any threat from outside people saying, "Hey, we don't like what you're doing, and shut it down." So we're super excited about the progress we've made this weekend. Emily, thank you. There goes slow mode. It just ruined slow mode for everybody, because now y'all can chat without any delay. But thank you, Emily. Appreciate it. Anyway, I'll talk more about that. We've got some cool plans in the works for expanding how we can get these court feeds and get them to more people, which is what I love doing. I mean, it's like, I mean, you see my studio. First of all, I'm on vacation, so this is the Airbnb. I'm barefoot in the studio. This is what I brought with me on vacation. I'm a bit of a nerd when it comes to that, so loving that. Beautiful outside, by the way. Let's see. Let's see. You can see I made my bed, didn't I? Yeah, it looks good. There's a mess of cables behind me. That's everything I brought back from court. Let me tell you really quickly what happened with court. This particular judge, Judge Mraznik, I can't say his name. It's got like 2 syllables next to each other, and it's impossible. Amazing judge. His voice is like butter. It is so smooth. It's so deep. The resonance it fills your soul when you hear him speak, and it adds an extra weight to everything he says. But the way he runs the media in his courtrooms, he says you can't even have the camera in the courtroom, which only allows 1 camera and 1 still. So we had an AP photographer, and KUTV 2 News was our pool camera in the court. So they couldn't even turn the camera on until the judge sat on the bench and basically called it to order. So you turn the camera on. It takes a second. All of us are scrambling because we're in the jury deliberation room because there's no jury, and we're sitting there, and we have no feed. It's just dark in there, as far as video access. And as soon as the thing comes on, we're all scrambling to hit our record buttons, go live. And so everybody missed the first little bit, except for me. I've got it, and I'm going to share it with you, what happened this morning. But none of us could get it broadcast because it takes a second to make that link with broadcast, and you can't start the broadcast until there's a signal. So I've got it recorded. I'm going to play it for you now. It's just the first few seconds. It messes it up on everybody's broadcast, including mine, like the first minute, 30 seconds. It gets all garbled because there's nothing there. But we'll play that for you, and then we're going to go over what happened in court today. I think personally that today, even though it was the shorter of the 2 days in trial for Kouri Richins, was the most intriguing because we got to get into the arguments, the legal arguments, whereas the previous days was just like a teaser of the evidence, right? A preliminary hearing, it's not for the state to prove beyond reasonable doubt all the evidence they have against the witness. They just have to show that they have some evidence to support all the charges they're charging them with. And the judge has to look at it in the light most favorable to the state and say, if you have some evidence, even if the defense has other evidence that's more convincing, that's fine. That's an issue for the jury for trial. But as long as the state has some evidence and is presented enough to support the charges for all the elements in the charges, then they can move forward. And so that's what happened today. We got that argument back and forth, and it was a lot like watching the Supreme Court question lawyers because it's a discussion between the judge and the 2 sides. I loved it. I was grinning from ear to ear for the whole thing. I loved, there were some spicy moments where the judge started dropping some F-bombs. Ooh, that was fun. We'll get to that. But yeah, it was just fantastic. So, but I'm not sure if we have any birthdays before we start playing court. Brandy Churchwell is covering the Telus verdict right now. We sort of sent everybody over there. I don't know. I was surprised it didn't last like 5 minutes of jury deliberation and then have a verdict. But instead, it's been crazy. We'll have to check birthdays in a little bit. Emily, thank you so much. I'm looking at all the names that are green now. That is just amazing. Thank you. Appreciate your generosity. Let's kick off court then. Once again, I do have the other video feed up that is clean. If anybody needs like this version that I'm about to share that has the beginning, I can put that up on a WeTransfer and get it over to you, or we can put it over on the Top Mark Media channel just as a plain file if you want that. It only misses a couple seconds. This is the recording with the audio levels that the court had, and the court was really strict on where the mics could be and how close they could be and whether they could be pointed at anybody. It was ridiculous. So I'm going to tweak that sound once again as we're listening to it live, so you get to hear it better than everybody else got it. And I think that's it. Should we kick it off? Let's see. Emily, thank you very much. I appreciate the kind words. I love court. But I'm like, if you ever watched Napoleon Dynamite, where the guy's like, I love technology, that's me, right? I'm the guy who loves technology. And getting to marry these 2 things together was just, it's a dream come true. So let's go ahead and jump to, let's see, camera 2. There's our judge. I'll be giving commentary on this one, so if anyone needs this without the commentary, let me know. I'll make all these files available to you, or we'll put it up on Top Mark Media, either way. And I still have to upload, I don't want to do it all live, but I still have to upload part 2 of yesterday's files. I've got those as well. That's about 2.5 hours. A lot of financial stuff on that one. So it feels like Murdaugh round 2, with some of the financial, the loans and the applications, the insurance and everything else. But we'll get that up there as well. But I wanted to go over this today. So let's begin with the judge and kick it off.
Jeremiah, just give me a thumbs up when you're ready.
I'm ready.
Okay.
Thank you.
We're on the record 231-500-139, State of Utah versus Kouri Richins. Can I have counsel for the state make their appearance, please?
Good morning, Your Honor. Brad Bloodworth, Lindsay Shervanack, Joseph Hill, and Fred Burmester for the state.
Welcome to all of you. For the defense, please.
Good morning. Wendy Lewis, Catherine Nestor, and Alexander Ramos for Ms. Richins.
Very good. Welcome, Ms. Richins. Mr. Bloodworth, just confirming, the state has rested.
Yes, Your Honor, the state has rested.
Okay. Ms. Lewis, are you calling any witnesses?
We're not, and we've advised Ms. Richins of her right to testify, and she's chosen to follow our advice, and she's not going to testify in this hearing.
Ms. Richins, I just need a clear record. If you would lean into that mic for me. You understand you have the right to testify at this preliminary hearing, correct?
Correct.
Are you following your attorney's advice and waiving that right?
Yes, that's correct.
Okay. I accept your waiver and find it's knowing and voluntary. Mr. Bloodworth,
love how
is
thorough
one
this
person
is.
doing the arguing, or are you breaking it up?
Your Honor, I will argue I may, on occasion, for some detailed financial information, turn to Mr. Burmester.
Okay.
But I intend to otherwise argue.
All right. Happy to go wherever you'd like. I do have a few counts that I have specific questions about that I can list for you if that would be helpful.
Yes, Your Honor, I think we'll go there. Maybe I can anticipate this a little bit.
Sure.
I'd like to note at the outset, other than the hearsay evidence that the court addressed in a private or non-public hearing yesterday, right, all the other evidence that the state references in its bench brief has been placed into evidence. So the court can rely on that briefing. I suspect, considering that the court has already found substantial evidence at the detention hearing related to the homicide, aggravated homicide charge, and since there's really no evidence to undermine the credibility of the existing evidence, and the state has added evidence, mostly in the form of 1102 statements from Ms. Lauber, Mr. Jeffs, Ms. Lloyd, and Mr. Grossman, and also considering that the financial charges are mostly paper-based charges that the court can read. Considering all of that, my sense is the court is most interested in hearing arguments on the attempted homicide charge, and the distribution kind of goes along with that. It really trails it.
So let me be specific, but I'm happy to go wherever you'd like to take me, but counts 2 and 4 are linked.
Yes.
And I have questions about the state's view of those. I do have some questions about counts 8, 9, and 10, only because I'm not sure I understand specifically the conduct that the state believes.
Those are the last 3 are the forgery
is
charges
associated with each of those 3 counts, but we can get there.
Yes, Your Honor. Let's start with 2 and 4, the attempted homicide and the connected distribution. In the meantime, Mr. Burmester may start thinking about 8, 9, and 10.
There.
But I
throwing
also
counsel is
may
like, hey, prep
address
an
them
argument.
as well, depending on the specific questions. Let me begin, Your Honor, on the attempted homicide bind-over argument. This is a domestic violence case.
Right.
And to best understand the attempted homicide charge, the court should view the defendant's conduct through a wide-angle domestic violence lens. And consider the entire arc of the criminal information and all the evidence that supports it.
May I ask you a specific question about that?
Yes, sir.
Listen to how well thought out these questions
To what
are.
extent can I consider the probable cause showing that of the aggravated murder in March when considering whether the state has shown probable cause of an attempt in February? The reverse would certainly be true.
Sure.
I'm unclear as to what extent I can consider the March events as probable cause for the February events.
Your Honor, you can fully consider it, and the court should fully consider it. What happens before a charged event and what happens after a charged event is probative of the event, particularly in this case. Let me maybe explain in some greater detail.
Sure.
Thank you, Troy. Congratulations.
And I guess further to that point, Your Honor, to consider the attempted homicide in isolation or as a discrete event, I think would be an error. The best evidence of the attempted homicide by poisoning on Valentine's Day is the actual homicide by poisoning 17 days later.
This is some weird logic.
All of the
that's gonna follow
defendant's
throughout
motive
this
that
story.
existed for the homicide also exists for the attempted homicide. And maybe let me just kind of detail some of that for the court. I don't want to belabor the briefing, but there's some highlights that I think...
I agree with you. The financial motives that existed in March existed in February.
That's correct. But it's not only the financial motive, Your Honor. There is, and I don't want to recap it unless it's helpful for the court. I can recap the financial motives.
I think I have those.
I don't think he was prepared to argue this.
Your Honor, the second motive that is just as present in February as it was in March, 17 days later, was her love interest in Mr. Grossman and their planning of the future. And specifically, the purchase of the $3 million Midway mansion where she discussed raising children and farming with him about a month earlier.
I guess what I'm saying is you don't need to prove motive beyond a reasonable doubt. The state has shown probable cause for it.
Okay. So then I guess the takeaway, Your Honor, is that the same motive for the charged homicide it's identical to the attempted homicide.
I agree.
Okay, I will move on.
Yeah. And candidly, I think the state has probable cause that she procured fentanyl prior to February 14th. The state has shown probable cause that she wanted something stronger after February 14th and sought it again. Made a reference to the Michael Jackson stuff, which I think at least at the preliminary hearing stage I can take judicial notice, refers to a well-known event in which someone took a controlled substance and died.
Sorry, just
I'm
realized I
tracking
had to
all
fix
of
the
that.
audio properly. Here we
Where
go.
I stumble or where I pause is, do we have an evidentiary foundation for a non-speculative inference that she actually gave Eric Richins a controlled substance on February 14th?
So we do, Your Honor. Let's...
Or attempted to do so.
Sure. Let's kind of focus in then on February 14th with the understanding that she 2 days earlier, the probable cause understanding that she 2 days earlier purchased fentanyl from Ms. Lauber.
Got it.
Okay. So her conduct on Valentine's Day helps establish that she, in fact, provided the fentanyl to Eric Richins. And so her conduct that day starts early in the morning when she purchased the sandwich from the Mirror Lake Diner.
Well, we know she makes a purchase from the Mirror Lake Diner, right?
Yes, sir.
We don't know that it's a sandwich based upon.
The state says she
business
poisoned the
law.
sandwich.
So we do. The invoice from the Mirror Lake Diner entered into evidence as Exhibit 66.
Go ahead.
Shows I think it's labeled on the invoice as breakfast sandwich.
Yeah, bagel sandwich.
Okay, bagel sandwich. And Your Honor, we also know from the defendant's own words that in her text message with her best friend, she admits to purchasing a sandwich that day.
Remind me, which exhibit is that? We're gonna need to talk about that.
I'm
in
gonna
detail.
need
Yeah.
some help on that example.
I know what you refer to, but I just need to look at it with you.
Yeah, I might have it in my notes, Your Honor. If not, we're working on that on the side. I'll get.
But keep going. We
I'll
can go
get that.
chronologically.
So we know from the invoice and from her text message that she purchased a sandwich that morning from the Mirror Lake Diner. We also have, as the court's seen, bank statements that confirm a purchase, phone call that confirms an order. The receipt corroborates, the invoice corroborates that the phone call is related to the order in Exhibit 66. So she purchases the sandwich from the Mirror Lake Diner. I think it's something like a 9:07 pickup is what the invoice shows. We then know at 9:43, the defendant, it's Exhibit 8, Your Honor, is a text message with her best friend.
Okay.
This judge is going through every exhibit
We then know
in
at
detail.
9:43, she text messages her paramour that she's on her way. And at 9:49, she sends him a navigation screenshot that shows her kind of leaving the Camas area with an arrival time at some unknown destination approximately an hour from them.
Soul Glow, happy birthday. Thanks for being here.
Um,
I am about 20 feet
We
to his
also
left,
know,
and I'm in another
based
room.
on her text activity with her paramour, that they were essentially together all day. And we know that because, as the court can see, they text frequently throughout the day. But throughout that day, they weren't texting with each other. And I think the reasonable inference is they were not texting with each other because they were together. While the defendant is an hour or so away from Eric Richins with her paramour, Eric Richins has some medical event strong enough that he texts the defendant and says he's considering going to the hospital. We have that text exchange in evidence.
Right.
Feeling sick enough to go to a hospital, and then sleeping in the garage, which he also texts, for about 2 hours, which is consistent with no activity on his phone and associated devices. All of that is consistent with the reaction to fentanyl.
This, I think, is the weakest part of the state's
But I
case.
can't remember the number. The number for the 1102 from the person that lays that foundation regarding a reaction, if any.
Yeah, so that's the toxicologist, Matt Slauson.
Okay, thank you. Keep going.
Your Honor, also in evidence is literature from the Mayo Clinic, which lays a similar foundation. Okay, so we now have, right, on the chronology of Valentine's Day 2022, the defendant and her paramour an hour or more away. Eric Richins sick enough that he's considering going to the hospital and is inactive for 2 hours. All of that consistent with fentanyl poisoning. And then at that point, the defendant's own words are kind of important here because he texts her, right? of his illness, of considering going to the hospital, and what she says is chilling. She says, take a nap. And then she doesn't check on him for 2 hours. She doesn't come home, she doesn't text, she doesn't call, she doesn't check on him. Their next communication is 2 hours later when Eric Richins checks in with the defendant. Notably, throughout the day, Valentine's Day, and thereafter,
Kouri and I
the
wore matching
defendant's
shirts today.
reaction to Valentine's Day events is consistent with a consciousness of guilt.
Defense
She
has a good
texted
argument
on
against this charge.
February 11th and 12th,
We'll get to that.
significantly with her drug dealer during a time frame that corresponds with the drug dealer's purchase of fentanyl at the Maverick and the Draper.
Right.
Those texts are deleted from her phone. She texted with the drug dealer 30 times, about 30 times with Mr. Kotrodimos' testimony. On Valentine's Day, and those texts are deleted. There is no good reason the defendant is spending Valentine's Day with her paramour and texting her drug dealer 30 times. Eric Richins texted the defendant a photo while he was texting her about feeling ill and considering going to the hospital. That photo is deleted from the defendant's phone and also from Eric Richins' phone. That is in the moment consciousness of guilt. The next day,
Who's snorting?
Forgive me, I don't recall testimony from Mr. Kotrodimos or any documentary evidence about when those images were deleted. Now, I acknowledge they were deleted sometimes after they were created, but...
Fair young.
Okay. Okay.
The next day, after Valentine's Day, February the 15th, 2022, the defendant lamented to her paramour,
Keep saying paramour.
if he could just go away, ... life would be so perfect.
Yeah, that looks bad.
And then 2 weeks later, she assured her paramour, life is going to be different, I promise. Hang in there until Friday. On Friday, Eric Richins was dead. We've referenced Exhibit 8, the text messages that the defendant sent to her best friend.
I don't think that's 8. I think Celebrite is 8. Can you give me that number again?
The judge has gone over every page of this.
Your Honor, it would be found in the
Every inch.
Celebrite extraction.
Oh, my apologies. Okay.
So,
It's not like a screenshot, it looks like a download.
Let's get there together. I need the exact language of that. It would be...
There's never been a moment during this trial where the judge looks distracted or just off doing something else.
Okay, got
He's
it.
always
So this is, we
elbows
gotta be
deep in the
specific about
evidence,
this.
taking notes.
A June 18, 2022 communication, correct?
yes, Your Honor, it is
Okay.
June 18, 2022. I can give the court some context, which the court's already familiar with on the timing. The timing relates to the same allegation kind of is wrapped up in the attempted homicide charge that was made in the civil litigation. And timing would suggest, I think it is reasonable to infer that they were discussing this incident. This text is a discussion of the Valentine's Day 2022 incident as put forth publicly in a civil filing.
I have some questions about this when you're done going through the evidence.
Okay, sir.
I also have questions about the February 15 text messages, so just put 2 pins in those.
Okay.
When the judge says he has questions, that means the
About
prosecution needs to address
questions.
this. Because he has doubts.
No, sure, sir. That glance was to get a copy of whatever the February 15th text was.
Well, see, if you would just go away, ... and then
Yeah.
I promise we'll be together on Friday or words to that effect.
Yes, Your Honor.
Okay.
We can discuss those kind of texts when we're both looking at them.
Okay.
The text to her best friend regarding Valentine's Day. The defendant says, it was Valentine's Day and Eric and I were both working from home that day. We know that to be false. We know that to be false from her text messages with Eric himself. We know that to be false from her text messages with her paramour. We know that to be false from the navigation screenshot. Continuing with the text, she says, he, meaning Eric, never broke out in hives or used an EpiPen. She did not know that. She was not with him. The court can reasonably infer that the opposite is true. She is lying about being with him. She is lying about him not breaking out in hives. She is lying about him not using an EpiPen because she knows those facts are indeed true and indeed inculpatory. Sir, do you want to discuss those texts, or should I continue on with kind of further answering your question as how the homicide charge kind of relates directly to the attempted homicide?
This is the lawyer asking if he's convinced the
Well,
judge.
let's pause here for a second.
Yes, sir.
We also skipped over or didn't mention in that recitation. Remind me of the date where she asks CL for something stronger.
So, Your Honor, that I don't know that I know a precise date. It's somewhere around February the 25th.
It's here somewhere. I think it was 12 days later, right? Okay.
And Your Honor, the court raises an important point, right? I said at the outset that the best evidence of the attempted homicide by poisoning is the actual homicide by poisoning 17 days later. And the defendant learned from the attempt and applied it to the homicide. And we see that with what the court just raised. She wanted something stronger. She learned that whatever she used on Valentine's Day wasn't strong enough, which is why she went back and asked for something stronger. But she had a similar MO, right? You know, her MO is to go to the drug dealer, procure fentanyl, and 2 or 3 days later, 4 days later, administer the fentanyl. That is the same. The drug is the same. The drug dealer is the same. The timing is the same. But she learned. She learned she needed something stronger. She also learned how to administer it. She learned that putting it in a sandwich where Eric Richins could take a bite, feel the effects, set the sandwich down, was not the proper way to administer a fatal dose of fentanyl. Instead, she administered it with a lemon shot, where Eric Richins would throw it back all at once. She says that in her journal article, her journal note at Exhibit 49. And she learns that it takes a truckload of fentanyl to kill her. She learns that one bite in a sandwich isn't enough. It has to be stronger, it has to be administered at once, and it has to be a lot. And that's why Eric Richins' toxicology shows
Listen to this.
5 times the lethal amount in his blood and 20,000 nanograms per milliliter remaining in his gastric fluid.
It's a lot.
The attempt and the homicide are connected in MO and lessons learned.
If we view, let's imagine for a moment that everything through February 15, well, February 26 stays the same. Imagine Eric Richins is still alive. The text message on June 18 gets sent. I imagine you tell me we'd still have probable cause of attempted murder.
We would, Your Honor, and I guess that goes back right to the standard of this hearing. You know, all reasonable inferences go to the state.
Right. And I hear you telling me it's a non-speculative inference that you tried to poison him because we have her admitting that she ordered lunch from Mirror Diner. We have him having a significant enough event that he contemplates going to the hospital. We have text messages on February 15 that draw reasonable inference that she wanted him dead. We have her out looking for something stronger when he did not die on February 14. We have a financial motive. We have the medical foundation.
These
The
are all things the
difficulty
state's
is,
pretty much
right,
got evidence for.
And maybe this just highlights the low threshold that is the probable cause determination. And I imagine this is what Ms. Nestor or Ms. Lewis is going to tell me, is this turns just about every possession charge into an attempted murder charge if the spouse has some medical event around the same time.
You hear that?
But here you'd say,
And the spouse dies 17 days later under very, very similar circumstances.
Turns
Same
every
medical
possession
connection
charge
between the two.
into
and is
attempted
it
homicide.
404 that lets me connect the dots here?
I love the judge just thinks out loud. Takes me back
I
to
don't even think the
Sherwood.
court has to go to 404. I think the court can connect. I mean, certainly it's probative. Certainly it's relevant. I guess the court could have connected dots through probative, but there's no doubt, especially returning to the fact that this is a domestic violence case. The court sees the consistency in the domestic violence defendant's conduct throughout. The motive is super strong. I mean, I know we've kind of agreed that the motive is present in both circumstances, but
It's equally present. It's separated by merely 3 weeks.
correct, and
Yeah.
it's equally as strong. Now, Your Honor, the court raised, that this isn't speculative, and it's not. And Schmidt kind of talks to the notion, the point, right, that the court's job here is not to sift through the evidence and find the most
Right.
reasonable explanation, just to make sure that the state's the most reasonable inferences, just to make sure, rather, that the state's inference is reasonable, and we leave the most reasonable inference question to the jury.
Okay. All right, so
I'm going to show a
if you've got
few
probable cause for count 2, you've got it for count 4.
pool
Yes,
still
I think-
images. while this is going, just to show you some of the
Two
close-ups.
goes
of
as, or
candidates.
4 goes as, 2 goes.
Right. I think I understand the state's position here. You will, of course, get the last word on counts, on all the counts, but certainly counts 2 and 4. I have some questions regarding some of the financial counts.
Yes, sir.
Bear with me for a moment. All right, count 8 for insurance fraud. What is the conduct that forms the basis of that count? Count 7, the $100,000 true stage policy. I'm following the state's argument. I'm not sure what count 8 refers to.
Hey, I'm going to show some still images while this is going on.
Yes, Your Honor, and in the statute under count 8, the insurance fraud statute has different non-exclusive, or I guess different exclusive theories of presenting an insurance fraud claim.
Certainly.
And then count 8 is kind of the broadest claim. It's the scheme claim.
False representations regarding how Eric got the fentanyl in him. Either one of those, I think, would get you there.
Yep.
Let's just say it's the false statements regarding the fentanyl.
Sure.
You have a forgery count
Sure.
regarding the false signature, I think, in either, bear with me, 9 or 10, or maybe 11. Candidly, I think 11 is the forged signature on the $100,000 policy.
Sure.
So
That relates to the claim, right? Count 7 is a false claim
right.
on an insurance policy. Count 8 is a scheme devised to get money falsely from an insurance company.
But
can or cannot involve a claim.
fair enough, but is it the... I acknowledge that we don't need to get into merger today, but
Sure.
is it the forged signature on the $100,000 true stage?
Sure, it's the signed application on January 28th and 29th. It starts with the application for the policy that issued on February 4th,
right.
10 days before the attempted homicide, a month before the homicide. It starts with that signed kind of application that the court will recall. There was no way for the insurance company to contact Eric Richins. Rather, they could only contact the defendant, right? The defendant used her business P.O. box. The defendant used her email. The defendant provided an improper phone number.
Okay.
And so submitting that application begins the scheme.
Got it.
Then the scheme continues through the false claim for the money. And the evidence of that is the claim log we submitted into evidence as Exhibit 67. But different than the false claim where the mens rea and the actus rea is just submitting a false claim with the intent to get paid on it. The scheme is much more sweeping. The scheme in count 8 is, I'm going to submit a false application for insurance on Eric Richins' life. I am going to then cause his death and then seek money.
Understood. All right, so with respect to the 3 forgery counts, 11 is allegations regarding Eric Richins' signature on the application for the $100,000 true stage policy.
Correct, Your Honor. That's the policy of Exhibit 17.
They're talking about the link between forgery and insurance fraud.
9 is the fraudulent bank statement that the defendant provided to Ironbridge, and 10 is the similarly fraudulent statement that the defendant presented to Boomerang.
She cut and pasted her
Those are
bank
the cut
statements.
and paste job
Got it.
statements.
Bad.
And so the forgery count of 9 is related to the mortgage fraud count that is in 5, right? And then the forgery count 10 related to the mortgage fraud count in 6.
Correct.
Got it. Okay. Thank you. Anything else you want to put on the record at this time?
No, Your Honor, I'll be back.
Very good.
He gets the final word. Now, defense gets to go. The whole purpose of this is just to prove whether or not there's enough evidence to go forward with the trial against Kouri Richins.
I'm going to address religious counts 1 and 3, and a little bit of 4, and then Ms. Nestor is going to address count 2
Okay.
and the remaining counts.
Tell me where you see the gap on count 1.
All right, well, here's where I see the gap on count 1. So I understand that there was a finding made at the detention hearing. And I understand that the court can consider the transcripts from that hearing. However, I think we're in a kind of an interesting situation, because the burden of proof has to be at the preliminary hearing, and the court does need to make a new finding at this hearing. And
Count 1 is
I
aggravated
actually think,
murder.
interestingly, that this is a situation where additional information that came in makes it less likely and makes it more difficult for the state to establish a reasonable belief as to the first element of aggravated murder, that she actually intended and knowingly killed Mr. Richins. Because what we learned yesterday is we have now the affidavit, or the 1102, from Ms. Lauber. But what that really tells the court is only one thing, is that she believes she gave fentanyl to Ms. Richins. She doesn't know what she gave Ms. Richins. Whatever she gave Ms. Richins has been through at least 3 people before it came to Ms. Richins. Ms. Lauber got it from somebody, Mr. Crozier, who got it from somebody else that we don't know who that other person is. None of these people manufactured it. None of these people tested it. So we don't know what was given to Ms. Richins.
I don't disagree that we don't know, but knowing is not the legal standard that I am required to apply today. So tell me why Ms. Lauber's 1102 is insufficient to support a reasonable belief in the parlance of preliminary examination law that the stuff that she provided was fentanyl.
Well, let's look at the distribution counts and examining that.
Yeah, we can't do anything about that. All right, go ahead.
So, looking at the distribution, and then I'll backtrack a little. So, Detective O'Driscoll said that he had no way of knowing, that he did not know what was in the pills.
He just knows that they are blues or greens, which, given his experience with, didn't say narcotics, but with controlled substances, is consistent with street fentanyl.
Blues, he said.
Okay, there you go.
Anyway, I was trying to remember if this was in the record or not before I said it out loud, so that's what was my pause there. But I have never seen a distribution case where we don't have anything that was distributed.
You mean a preliminary hearing or a trial? 2 very different universes.
Well, personally, neither. Okay? Personally, I've not seen it either place. But I don't think just an individual who's a drug addict saying, I thought I gave her fentanyl,
Doesn't that form the reasonable belief, though? I mean, by all accounts, Carmen Lauber knows the difference between a controlled substance and not.
Well, that's not in her affidavit. How do we know that? How do we know that she knows the difference?
With respect, she's in drug court and she faces controlled substance convictions. So apparently she has some kind of experience with it.
But Detective O'Driscoll testified that she said initially, and she said it in more than once, that she knew nothing about fentanyl. She didn't deal fentanyl. It's not her drug. And he said that.
These are great trial arguments, but I question whether this would be sufficient to, these concerns are sufficient
trial
to
arguments.
rule that there's only a speculative basis rather than a reasonable basis.
And I understand.
There was provision of a controlled substance.
Let me understand your position and where you're headed with this, but I do think we want to, for the record especially, Detective O'Driscoll testified that he cannot say with any certainty what happened to those pills. We have no knowledge, no testimony, no evidence, even if those pills were fentanyl, what happened to them after February 25th. I mean, the third ones were allegedly received after Mr. Richins' death, which is interesting in terms of what these pills were actually for. And I think, and again, maybe a trial argument, but it's interesting that if that was the purpose of these pills, that they were still being handed out afterwards. But he said he could not testify what happened to those pills. He cannot testify what was in those pills, and he does not know how, if those pills were given to Mr. Richins, and if they were, how they were given, who gave them, did he take them himself? There isn't any evidence as to that. And I understand, the position and the very low standard we're looking at here. I get it. But that would be...
To be clear, the court's position is based on an application of the standard, not because I have an independent
I
belief
understand.
of what did or
And
didn't
I didn't mean to imply that it was your personal belief. I understand the standard.
Right.
And your application of the standard.
I'm going to show you the
Our
counts
position
against
is
Kouri
still
really
that
quickly.
there needs to be something more when you look at everything that's been presented as evidence in this case up to this point. And particularly on the distribution count, I think it's...
3 or 4.
Well, to both, but there's additional, of course, problems with the February 14th distribution count.
With count 3, though, I mean, if there's probable cause for if there is evidence sufficient to support a reasonable belief that Kouri Richins put some drugs in a drink and handed it to Eric Richins, there's probable cause for the count 3, right?
Yes.
She admits.
All right.
Yep.
You're right.
You're right.
But I think I've made my argument on that. And I just don't think that anything that happened from any of the other witnesses, of course, goes any further to show anything about count 1. It goes to the motive, which is an element of count 1, especially the Ms. Carrington's testimony. I understand that. But nothing that they said, I think, goes to intentionally or knowingly administering the drugs.
Well, the motive would provide some foundation for intentionally or knowingly. Let me put it differently. If there was no motive, the inference would be harder to draw, correct?
Yeah, you're correct.
Okay.
I think that covers what I have in our record on that. I don't know if you have any other questions, but Ms. Nestor will talk about counts 2, and then that, of course, relates directly to count 4. And she'll address the financial counts.
Okay. I think I understand your position on 1 through.
Okay.
Thank you.
So now switch. We're going to address a couple other counts. They're not addressing all of them. They're not trying to fight everything. I think mostly they just want that attempted murder one gone. They're not going after the big one.
Good morning, Your Honor.
Aggravated murder.
May it
They're going
please
after
the court.
attempted murder, trying to get rid of that.
If the court would indulge me, just a couple minutes. I know you're so familiar with preliminary hearings. You do about 1 billion of them a year, probably. But I do just want to talk about what they are and what they mean to this system and to my client. So, Utah is a state that has decided not to employ the grand jury system to determine whether someone should be prosecuted for a felony crime. Utah has decided to place the entire power of whether someone's going to be dragged away from their home in handcuffs to a courtroom facing serious charges to the discretion of these people at this table. It's their power to fill out an information.
I have some role in the process.
Yes. I'm talking about before they get to you. I haven't got to that part yet. You're jumping ahead of me.
Okay.
But what brings them to you is the people sitting right here. And it's their opinions, it's their beliefs. They're not a grand jury, they're prosecutors, they do their best. So what we have created to protect clients from that awesome power that sits at that table is this process of a gatekeeping, that instead of delegating that to a grand jury, people in our society that come together in closed doors and hear the evidence and decide whether there's enough to put someone through this, they bring it to you. You're the gatekeeper. And this preliminary hearing is a critical right that every single individual who they decide to write a charge against has. And when we come before you, we recognize that it's a low standard. We recognize that probable cause means that. It just means enough to charge you. It doesn't mean enough to convict you. It doesn't mean enough to determine you committed a crime. It's enough to charge you. But that charging decision does matter.
Welcome,
and it's
Judy.
going to have a huge, huge impact on the way this case plays out, on the evidence that is brought before the jury, on who will be witnesses, determining what charges get past this gate, you the gatekeeper. So we believe very, very, very strongly that the charge of attempted murder has not met the lowest standard even of probable cause. And that as rare as it is for a judge to say there's not even enough to charge here, it is anticipated that that will happen on occasion, which is why you do thousands of these, right? Because every once in a while, they don't get up to that level. And we think in this case they haven't done it, and we'd like to tell you why. So thank you for indulging me that.
I agree with everything you said about the law.
Okay.
What is the essential element of count 2 that you believe the state has either shown no evidence of or insufficient evidence to draw a reasonable inference regarding?
Causation. 100% causation.
Strong answer.
In order for them to establish an attempted murder,
Right.
they have to show that Ms. Richins took some act that caused someone to be in danger of death, right? She had to have caused something that put them at risk, right? Whether they actually died, obviously it's attempt, right? So I think it's critical that you understand the timeline of that day. And I want to walk it through, and I know it may take us a couple of minutes, but I think it shows so clearly that they cannot make the connection. And it's indisputable evidence that's in the Celebrite that has been downloaded off their phones. There's no debate about what happened on those phones, okay? So, in Exhibit 6, there are substances of text between Eric and Kouri that say exactly their communications that day. I want to go back to the very beginning, which is the receipt, which is Exhibit 66 from the Mirror Lake Diner. It shows that Kouri's credit card swiped at 9:07 a.m. and that she ordered a bagel breakfast sandwich and an omelet. There is a statement under the sandwich that it's over hard, which means it's an egg sandwich. There's an egg in that breakfast sandwich, and I think that's important because I don't know about you, but I'm not eating an egg sandwich 2 to 3 hours after it's brought to me. You eat it quick or you don't eat it. So she brings an egg sandwich home at 9:07. This actually hasn't come in, but I think the court could take judicial notice because of the address on Ms. Carrington's exhibit about the Willow Creek home where they resided. It's about 5 minutes away from this cafe, and I don't think that the DA will, or the county attorney will dispute that.
Nothing in Camas is very far away.
Nothing in Camas is very far
Camas is a
away.
small town.
So it's about a 5-minute drive from the cafe to their home. So best case scenario of her credit cards being swiped at 9:07, she's getting home around 9:15 in that area, maybe.
Is there any evidence that she actually went home?
Correct.
Well, I'm asking.
There is. On her phone, the printout of her phone shows her returning back to. Well, actually, they've introduced that exhibit that they blew up that showed that she was on her way to the house, and that's from her home.
Okay.
So she was at home. So there's a period of time where she's at home between 9:15 and 9:41 a.m. with eggs to eat. Now, it is a fair assumption that when you bring eggs home, you eat them quickly. So it is perfectly possible, and just as inferential, that she could have had breakfast with her husband that morning together. And let me tell you why I believe that that's proven in the state's own case. Because at no point in any conversations, any texts between Kouri and Eric, does he ever tell her that he's feeling sick until he tells her at 11:40 something that if I'm still feeling this bad, I'm going to go to the hospital. So it sounds very much that they've already discussed that he doesn't feel well, right?
This is a good argument from the defense.
So it is perfectly consistent with Kouri Richins' statement to her friend. They ate breakfast together, which would make it pretty hard to poison someone when they're sitting there and you're handing them their food and watching you hand them their food. So then you have Eric between 10:21 and 12:06, and these are reflected in exhibit number 38, which shows the locations of calls made by Eric.
Could you pause for a second?
Yes.
Is there a statement that they ate breakfast together?
They just talked about her telling her friend lying that they were together when they ate.
So, I just want to make sure I'm not missing anything that you're seeing. Quote, forgive me, folks. I didn't even make him a fucking sandwich, those fucking idiots. It was Valentine's Day, and Eric and I both were working from home that day, and I ordered lunch from Mirror Lake Diner.
Well, that was months later, and she hadn't seen the time. She hadn't been exposed to any of
Hey, folks, I need you to take a deep breath. Is there any evidence that she has a backward-looking statement saying, I ordered breakfast?
Well, that's the only statement that we're aware of.
Okay.
But at that point, she hadn't seen the time. So she's remembering if it was breakfast, lunch, whatever. I mean, that was months later.
All right.
But she admits she got it at Mirror Lake. She admits they ate it together. She mixed up the time of breakfast and lunch. I mean, there's no debate. She was not there at lunchtime. That didn't happen. So, so that's clearly a mistake. So she leaves the house at 9:41 and is gone for the rest of the day. Eric drives to multiple other locations after she leaves.
Do we know, help me out, do we know that? Or
Yes.
was he doing the estimating from home? This was unclear to me from the testimony.
So in the Celebrate exhibit that is Eric's phone, it shows where he's making calls from.
Okay.
And so he makes calls from, I think he goes to it looks like the Smith's grocery store, the Walmart. He goes and runs some errands. He's making business calls ever since Kouri left, the whole time. After he's eaten the egg sandwich, he's driving around, he's making calls. Then he texts Kouri at 11:27 and talks to her about some soccer fees that the boys owe. And then says a few minutes later, so between 11:27, he's talking about soccer, at 11:33, so he hasn't seen Kouri now in 2 hours, he says, I'm going to go lay down. If I don't feel better, I may go to the hospital.
Look at the reflection on her iPad. It looks like Dwight from The Office.
I must respectfully point out that when the prosecution talked about her saying, go take a nap, and how that was chilling, he pulled that completely out of context of the rest of what she said in that text.
Do you need me to come home?
Would you like me to come home? Jesus, is that bad? You know, she even at one point later in the day talks about, he says, I wish you were here, and she's like, I would cuddle you. So that is very misleading to pull that statement out, and I need to correct that for the record. But regardless now, he hasn't been in her presence for 2 hours. If he ate that sandwich, he ate it around 9:30, give or take, at the latest.
Because no one eats cold eggs.
So in that period of time, he's been running errands, doing business calls, texting Kouri, very benign, normal day-to-day texts. Nothing about, I'm about to die, nothing like that. He takes a nap for 2 hours. Then he gets up. They text romantic texts, wish you were here, like to cuddle. That's at 1:43 when he just woke up. The same period of time well, I'm sorry, that's not before. I withdraw that.
Same period of time she's out with her paramour.
Continues to make work calls from 1:50 to 2:30. Goes to a soccer game with his kids from 3:52 to 6:11. Takes the boys to get some food. Leaves food for Kouri in his truck as they go back to the game because Kouri is running late.
Another egg salad sandwich.
And that's the day. That's the day that they are now saying that you can infer she tried to murder her husband. There's no evidence he ever took a pill from her. There's no evidence that she ever, that he was, if she put fentanyl in his egg sandwich at 9:30 and he ate it, he would not be okay for 2 more hours. He would not be. And there's zero evidence. There's not one piece of evidence from Eric himself that he ever took anything from Kouri that day, that he felt bad up until 11:33 is the first time he feels bad. Now, I think you asked a fascinating question when you asked the prosecutor, do I need to consider the death as support for probable cause of February 14th looking backwards? And I think that's a really important inquiry because obviously if you look backwards, everything you're looking backwards at shades how you look at something that happened before. But if you look at that count in isolation, there is no evidence that supports an opportunity for her. There's no evidence to support that he took anything. There's no evidence to support that he had fentanyl, OxyContin. And as a matter of fact, he told, wait, I have to think if this is in.
Can I ask you some specific questions about
Yes.
He told somebody he tested positive for COVID.
So let's take it one piece at a time here in terms of events after February 14th.
Yes.
In your view, can the court consider Ms. Richins' text messages to Mr. Grossman on February 15th? Can I consider them at all?
Can you consider them? I mean, I think you can consider anything you want to consider in terms of...
Well, see, that's the question. The Utah Rules of Evidence say, no, there's all kinds of stuff you can't consider under these set of circumstances. And it's often a difficult slalom course to ski. We did some of this yesterday morning, trying to get a sense from the defense of whether or not the court can consider things like the text mentioned, quote, if he would just go away, end quote.
So,
or as evidence of an inference that she wanted him not around anymore.
But that could be divorce. That doesn't have to be death.
And we're not at trial, and I'm not a jury, and so I have to contend with black letter law. Let me just get this out. I really am genuinely interested in your response. I acknowledge there are multiple credible inferences that can be drawn from this evidence. Several of them innocent. But I'm not allowed to pick and choose. I am not allowed to weigh the relative reasonableness or credibility of the inferences. I'm required to draw all reasonable inferences in the state's favor, to view the evidence as a whole in the state's favor, and identify is there a reading of the evidence that supports a reasonable belief. And so when you say things like, look, this evidence, she went home, I imagine Mr. Bloodworth is fighting the urge to jump up and say, and that just shows she went home to give him the sandwich.
I lost your sandwich.
That just shows he went home to give her the sandwich. She went home to give her the sandwich. And so the reason I ask about the stuff afterwards, the text messages, her statement regarding ordering them lunch, being home together.
So the text message certainly could be considered for the death, right? Because he's still alive and it's February 15th.
But that's not my question.
Right? So how does the how does the statement on the 15th relate to something that didn't happen? And she's talking about it in future, right? Like,
I guess the question is, if on February 15, she has a text message showing a desire to have him not around anymore, why can't I consider that for her mental state on the 14th?
she doesn't say he should be dead.
I know.
I'm not following the other trial right now.
It's,
Randy Church
you know,
was.
Criminal defense lawyers look at these phones, and it's pretty terrifying to think that someone's going to go back and look at text that you wrote about your spouse, you know, years later.
How many of us are
and put it
nervous?
all into a cone of
That was us.
literal death threats when you say, I wish he'd leave, he's getting on my nerves, I want him to leave the house, I'm going to leave him, I want to divorce him. Eric, they put in Eric's divorce meeting with his divorce lawyer. I mean, this was not a perfect couple. They didn't have a perfect relationship. But to take a context, one single text, and to say that that gives you a reasonable belief that she tried to kill him the day before, I don't see the connection at all.
Okay.
I don't think that is a connection.
So I hear you saying you can consider a judge, but it doesn't have any weight.
I don't think it does.
Okay. Same response regarding her June 18, 2022 text to her friend?
That's what we just said, where she has not seen yet the time, like she hadn't had an opportunity to review the timing. So if she mixed up lunch and breakfast, but everything else in there is consistent with what happened that day.
What about her text message on or about February 26th to Carmen Lauber saying I need something stronger?
He knows all these things. The judge has an
Again,
incredible mind.
That's after the 14th.
It's a backward-looking statement, though, or at least it's comparative.
Well, apparently she had recently apparently according to Ms. Lauber, she had just recently got something from her. So,
right.
I mean, that could be not connected to the 14th at all.
Okay.
So,
or more specifically, not necessarily referring to what she got on the 11th,
Right.
but could be from the 25th.
but I mean, you have a claim that Mr. Richins was poisoned on the 14th. There is no medical evidence. There is no connection. There is no causation. There is nothing but pure speculation that because they believe she tried to kill him and successfully killed him in March, that must mean she tried it before. That is not enough to reach a reasonable belief that someone, and that's the question you asked at the very beginning.
Right.
Just because, I mean, it's like a backwards acting in conformity argument.
Yes.
It's a backwards 404B evidence.
Well, this is my question.
Right.
Does that exist?
Which, by the way, 404B's whole purpose of existing in every state in America and in the federal system is exactly to avoid this kind of prejudicial leap of because somebody did something once, they must have done it again. That's the whole reason we have 404B, is to prevent that.
I acknowledge that. I imagine you would acknowledge as well the numerous exceptions and the lengthy or the deep body of case law regarding exceptions to the general bar to propensity evidence. And so here, when Mr. Bloodworth makes references to modus operandi, he's arguing to some of those exceptions.
Right. Well,
In your view, does 404B work backwards or does it only work prospectively?
It only works prospectively, in my opinion. But the analogy as to why this is such damaging and risky analysis can be found in that rule, baked into that rule that our legislatures and our Supreme Court recognize that that's very, very dangerous to base a prosecution on somebody, well, somebody used drugs once before in their life, they're probably guilty this time. That's the whole thing we're trying to avoid in our system. And that's the whole basis for their argument on the attempt. That's the entire basis, because they know they don't have proof. They don't have medical proof. They don't have, we heard testimony about allergies. We heard about all of that. So, I mean, there's innocent explanations for everything that happened on the 14th. Every single thing.
Including the
So
COVID
that
diagnosis.
doesn't lead to a reasonable belief. They are 100% relying on an action and conformity argument.
I don't think we heard the admissible testimony of allergies, but I take your point.
I'm sorry. I'm trying really hard
That's
to
okay.
separate it in my brain.
I understand.
I actually think it's included in the, I believe it's included in some of the exhibits, but we'll just leave it alone just in case I'm wrong about that.
I really like
I can
her.
check that while he's back up. But having said all of that, you know, the distribution charge that is connected to the attempt charge, if the attempt charge doesn't have probable cause, the distribution charge doesn't have probable cause. They both have to go.
May I ask you about the consciousness of guilt argument that the state makes?
Yes.
Which I understand to be my words, not the state's. Why is she lying in her text message to her best friend in June about what happened on the 14th?
I think the only thing she got wrong was breakfast or lunch.
Well, I think her location about her being home all day is one of the things they lean on. We were working from home that day, and
I mean, that's easily provable. So it's not like when she's talking to her friends, she's trying to remember the day back, you know, a few months later. And she got part of it right, I mean, and part of it wrong. And I just don't know if it's just, I mean, how do we know that, what purpose would that be? How would that serve as a lie?
well, the argument is that she's hiding the fact that she was with another person besides her husband on that day.
Okay, that's a good reason to lie, because you're with your boyfriend, and you don't want to admit you're with your boyfriend.
Right.
I mean, that's not conscious of guilt of killing your husband. That's not wanting to tell people you were hanging out with your boyfriend.
Okay.
But
that's
it won't,
one credible inference.
it won't
right?
accomplish anything
All
in this hearing.
Would you say that it's not a credible inference that the reason she's lying to her friend is because she had the scheme to be not present?
But she admitted she was present with him, and she was. She brought him breakfast.
Okay.
So that's true. That inculpates her more than exculpates her. That's the opposite of covering herself. She's putting herself in the house with him on the day that they're claiming he was attempted to be poisoned. That's a statement against interest,
Okay.
in my opinion. Okay. So I don't really need to argue the distribution. You get that. All right. So the only other things that we have on the fraud type arguments. I do think that the state never established jurisdiction or venue for any of those counts.
What?
I don't believe
Subject
we've
matter
heard
jurisdiction?
any proof about why this court has jurisdiction over these acts. They did not establish where they occurred.
Are we going to address subject matter
Why isn't
jurisdiction?
it a reasonable inference that Kouri Richins was making these applications and forming these schemes from Summit County?
And they have to show that. You can't just out of whole cloth make that up. There's no evidence that that occurred.
Well, the standard of proof is the same for every element of the crime, right?
But
So
there's no
of crime.
evidence that was submitted.
She lives here. Her business was based here. I think there's a basis for reasonable belief that she was initiating these contacts, forming these schemes from Summit County.
Well, I just want to make the record
Okay.
that I don't believe they've established jurisdiction or venue on any of those counts. Furthermore, on the, I don't see why the two insurance fraud counts don't merge here.
Correct me if I'm wrong. I'm seeing several merger issues in
Yes.
this information, but merger is a fact issue that's handled after conviction. Am I right about that? Not at a preliminary hearing.
Not after conviction, before, you said after conviction, you meant
Is it
after
before
charge.
submitting it to the jury or after?
Merger?
Yeah.
I always do it as a pretrial motion, but
Okay.
I may be wrong, I may be doing it wrong.
I don't think it gets considered though at a preliminary hearing as a matter of law.
Well,
Judge is right.
I think if you determine at a preliminary hearing that two counts are actually one act, that you cannot push forward one of them, absolutely, I think you could do that.
Do you
But
have a citation for that? I thought it was the opposite at a preliminary hearing.
well, I think you would just argue that they can't make two separate counts, so there's not sufficient reason to believe that a second crime was committed because it's all one. So that's your finding, that it's a reason. You can't reasonably believe the second crime was committed because it's just one crime. Because the scheme swallows the allegation of the filling out of the application. I mean, it swallows it. So
I'll take a look at this.
yeah. And then I think on the rest we would just submit on the other counts, Your Honor.
All right, so let's just be clear. To the extent that merger needs to be considered as part of the probable cause determination, that's going to mean that 1 and 3 merge, right?
Yes.
2 and 4 merge.
No, not 1 and 3. Attempted murder is on a separate day. It wouldn't.
1 and 3, 2 and 4.
I'm sorry, let me look at what 1 and 3 is. I'm getting my numbers mixed up.
So the distribution counts merge into the
1 and 3, aggravated murder and forgery.
And attempt, right?
No, those would be 2 separate crimes.
Tell me why you can't
distribution.
Because
commit them without doing the distribution, right?
Right. I think they don't merge though. They're separate crimes. Like distribution is a separate offense than the attempted murder.
Okay.
So they wouldn't
then
merge.
Why isn't on the one hand forging a signature and then on the other hand making a false statement when trying to collect on the claim? Why aren't those 2 separate crimes? What is the merger
Because
you're
they're
arguing for?
the 2 insurance fraud charges, because that is the same offense. Insurance fraud is not 2 separate offenses. And what they did is they said she created a scheme to wrongfully get insurance fraud. And part of that scheme was she signed the application and they just charged insurance fraud twice. I'm not talking about the forgery, I'm talking about the 2 insurance fraud charges. I think they merge.
All right. And just to be clear, you think they merge because it is the same fruit of the criminal conduct? That is, there was only one policy.
Right. That's correct.
Okay, I understand.
State's shaking their head. They don't
Thank
like
you.
that.
Can I just have 1 minute before I sit?
Of course.
So I'm surprised they played the subject matter jurisdiction card and said the state has not proved any of these charges as it relates to subject matter jurisdiction. Meaning you haven't even proven it happened in this county where the court has jurisdiction. And the judge can't that be inferred? And she says, no, we can't just spin that out of the whole cloth. You have to prove that.
Just one more thing.
Judge says he's not worried about that. I think there's enough location information tied to this that
And I guess maybe the last thing I would say too is there's so many reasons that Mr. Richins could have not felt well that day and taken a nap. And to get over the hump of saying you're going to stand trial for attempted aggravated murder, which is about the next to most serious charge you can ever be charged with, because he went to take a nap, is pushing it, Your Honor. We're just asking that the court exercise your gatekeeping function. Let's remove that from the confusion it will cause the jury, the prejudice it will cause the jury, the complete lack of foundation. We're asking that the court take the rarest of steps and say, this one will not go forward. And we submit on that.
And they admit it's rare for the court to do this.
Mr. Blow.
Your Honor, real quick on just the merger issue, it's 2 different policies. Count 7 relates to the, I think, $250,000 true stage policy, and count 8, I think, relates to the $100,000 policy.
That is not the way it is charged. I think that is, you're going to need to amend the information if you want to do that.
I don't want to
And frankly, I don't think there's any allegation of fraud, or there's any, tell me why there's any reasonable belief regarding fraud related to the $250,000 policy.
Fraud in the claim, saying that I don't know why Eric Richins.
That's not what she said with respect to the $250,000 claim. That was only with respect to the $100,000 claim. It's 2 separate diaries. This is why I'm asking.
Your Honor, I think
they were paid out at different times.
Sure, in the one diary, though, they discuss both the policies.
I don't think that's true. You can show me, but I looked at them carefully yesterday. They are separate diaries regarding separate policies.
Let me ask you this, sir. Is this an issue you're considering? And so I can show it to you, but I don't know that it's a.
I understood
real issue here.
You to be saying count 7 is based upon statements made during the process of collecting the proceeds in June. Count 8
7's mortgage fraud.
is the scheme to get the policy with intent to kill Eric Richins to collect.
8 is mortgage fraud. the judge is mistaken on this, I think, and they're going to set him straight. But it's funny, he's like, Judge, are you really considering like throwing this out? Because I don't want to waste my time arguing this if you're not considering it. Yeah, and he's like, yeah, I've got a question. So they're going to have to...
Are you referring to the statement, Mr. Burmester, of no known drugs, occasional cannabis use?
No, that
came out of the medical records.
Your Honor, it's Exhibit 18, page 1. It's the last note.
I see what you're referring to. So this is 803. Hold on a second. Let's get to the bottom of this.
Today is the last day of this hearing. We're going to find the conclusion here in just a few minutes. We're going to skip ahead after the break. The judge is going to make his ruling as to the hearing. I just want you to point out this judge, for having the best voice of any judge, has the cheapest chair. This is like Office Depot bulk furniture chair.
Backwards. Okay. So, count
No offense,
7,
Office
thank
Depot.
you for this clarification, is with respect to the $250,000 policy. Got it. Thank you for that clarification.
Your Honor, regarding the 404B discussion, the purpose of admitting the evidence is further to many of the exceptions, propensity, intent, preparation, lack of accident, nearly all of them. 404B just relates to whether or not the defendant acts in conformity with her character, whether that's prospectively or retrospectively is irrelevant. The most of the defense's argument against bind over the attempted homicide count, as the court kind of noted, a lot of that goes to the jury. A lot of that was arguing countervailing evidence. As the court is well aware, the standard today is notwithstanding countervailing evidence, whether that's countervailing evidence of how quickly Richins eats his eggs, or whether he goes shopping beforehand or afterhand. It's countervailing evidence. It does not apply to the court's analysis today.
Rybear, good evening. Congratulations on 4 months.
Part of that countervailing evidence, I find it ironic that counsel argued we hadn't heard one piece of evidence from Eric Richins. What questions does the court have?
I understand the state's
He doesn't know what else to say. What questions do you have?
to be saying
Anything you want me to cover?
conduct in March is evidence of other acts admissible to prove an MO. I understand the state's position.
And the lessons learned, I think, is very important.
Sure.
We've had some discussion with defense counsel also as it relates to the standards at issue for the probable cause determination. And I think the court has sufficient evidence when viewed in the light most favorable to the state, when giving the state all the reasonable inferences, notwithstanding the countervailing evidence, to find probable cause here even without the 404B part. The 404B part helps, certainly.
I love this argument.
But I don't even think it's necessary for the court to get to a probable cause determination. And, Schmidt, in discussing probable cause, references that, probable cause in a preliminary hearing is the same as probable cause for an arrest warrant. And if the state were to set forth all the evidence it has put, referenced in its brief, argued here today, and charge an attempted murder, and ask for an arrest warrant on the information.
Or a search warrant.
Or a search warrant.
Right.
And if the state submitted it to 100 judges in Utah, 100 of them would issue that warrant.
Check to speculation.
It's argument.
It's argument. She is so offended. Object to speculation. Overruled.
Okay. It is 11:29. We're going to come back at 11:50.
Liar.
Oh, Ms. Nestor, my apologies.
Quickly, I checked the ME report. It did reference the fact he was positive for COVID, but it did not talk about allergies in the ME report. That's where I thought it might be. But I'll keep looking and see if I can find it. But I do know that he did test positive for COVID.
Understood. Thank you. 11:50. Court's in recess. Thank you.
Okay, so as they go to break, I'm going to skip through this part a little bit. Let me fast forward because they took a lot longer than 11:50, just for the record. Come on, search. Ooh. Okay. All right, as we go fast forward, this was an amazing court to watch. So many people there already. This is a preliminary hearing. Just in the media room alone, we had the five big local news stations that were all present. I think it was 5, 2, 4, 5, 13. I think one of those is also CW30. But NBC was there, National, Court TV, Law and Crime, AP, Associated Press. The pictures I showed you, the still images, were taken by Rick, who was an amazing photographer. I've run into him at some other venues and sporting events and things like that. Okay.
I hope you feel better. Thank you.
Anyway, it was a lot of fun to be there. We were in the jury room. When this goes to trial, all the media is going to be packed into that little room with the glass window that you see at the back of the court. Here the photog was trying to format his cards, so that's showing his reporter from his station, Channel 2, that he was going to, we're all cut from that. He was trying to format the cards. Turns out he didn't have a card in there. He's trying to format, cannot proceed. Now we're, I think he like teases us like 5 times, so give me just 1 second. Let's fast forward a little bit until the judge shows up. He powers it on, powers it off a couple times. Oops. But a big shout out to the photog from Channel 2. Did a great job. Really appreciate what they did and how they did it. Very professional. Channel 2 has always been really good to work with in the media pool as well. Okay, we're just coming back from break. Hey, little RA, how are you doing? So the argument that the prosecutor made was really good, really good. I loved that they said, look, yeah, they've got stories about eggs. They've got, he could have been sick that day, everything else, but it doesn't matter for the hearing. You have to just look at it the way we tell the story and say, is there enough evidence that we can move forward? And I think that's going to be the key. I say that because I know how this thing ends. And it is extremely rare for a judge to throw out a charge at the preliminary stage.
Before the break about the merger doctrine.
Let me back up just a tiny bit to get this, because he... There we go. Okay, here we go. Play. Hey, bud.
We're back on the record. In case 231-500-139, Ms. Nestor, we had a conversation before the break about the merger doctrine. I confirm that as a matter of law, merger does not apply before trial, and in fact, the protections provided by the merger doctrine are not applicable before trial. The trial court cannot assess whether Under the particular facts of the case, one charge merges into another until the prosecution has presented its case and the jury has convicted the defendant of multiple charges. That's under State v. Lopez.
Merging only occurs
Utah Ave 410.
basically right before sentencing in Utah.
Which brings us to a discussion of what we are and are not doing today. First, what we're not doing. We are not determining in any degree guilt at all. Ms. Richins was presumed innocent of all charges yesterday. She is presumed innocent of all charges today, and she will remain presumed innocent of all charges through trial. Nothing the court says today affects her presumption of innocence in any way. Preliminary hearing is a specific thing with a specific legal standard. The state's burden at a preliminary hearing is to show probable cause for each offense charged, and the court must bind a defendant over for trial if the prosecution presents evidence sufficient to support a reasonable belief that an offense has been committed and that the defendant committed it. So even though the Utah Constitution provides criminal defendants with a fundamental right to a preliminary hearing, the evidentiary threshold at such a hearing is relatively low. At this stage of a criminal proceeding, the prosecution need not eliminate alternative inferences that could be drawn from the evidence in favor of the defense. And in reaching the bind-over decision, the court must refrain from assessing whether the prosecution's inference is more plausible than an alternative that cuts in favor of the defense. Instead, the court must view all evidence in the light most favorable to the prosecution and must draw all reasonable inferences in favor of the prosecution. And the court must leave all weighing of credible but conflicting evidence to the jury.
So that's the standard he's working with.
Here, having reviewed the evidence admitted, including the 1102 statements, the documentary exhibits that were pre-admitted, having considered the admissible sworn testimony of witnesses that testified live, the court reaches the following determinations. First, for the reasons described at the detention hearing, which remain valid today, the prosecution has shown probable cause that count 1, aggravated murder, and count 3, distribution of a controlled substance, both of which relate to events that are alleged to have occurred on or about March 3rd and 4th of 2022, are supported by probable cause. Ms. Richins is bound over for trial on counts 1 and 3.
That's the big charge.
With respect to count 2,
that's the
attempted aggravated murder, alleged to have occurred on February 14 of 2022. The prosecution has admitted evidence sufficient to support a reasonable belief of the following facts and events. That in January of 2022, Kouri Richins secured a life insurance policy on her husband's death, or her husband's life, through fraudulent means. That she had a significant financial incentive to
He's not reading notes.
secure
He's
his
speaking
death
from
because
memory.
she would do better under the
So
premarital agreement if he were dead, and her businesses were highly leveraged. Then on February 14, she purchased food for them both, including him. She described it as lunch in her text message to her friend in June. She was not honest about where she was going that day or what she was doing after she left the family home. Eric had a significant reaction to something that day, sufficient to make him consider going to the hospital. The state has admitted evidence that fentanyl can cause a serious reaction. There's significant evidence, at least to support a probable cause finding, that Ms. Richins had secured fentanyl by February 11th, and that on or about February 26th, she contacted her source again and said, she needed something stronger. These facts taken together would support issuance of a search warrant to investigate whether Ms. Richins had attempted to cause the death of her husband. They would support issuance of an arrest warrant for her arrest on attempted murder, and they are sufficient to support bind over under the probable cause standard.
So 1 and 3
for attempted aggravated murder on February 14, 2022.
and now 2 and 4.
The court makes this determination without considering the probable cause that indicates that Ms. Richins actually caused the death of her husband on March 4th. And so while the court is considering evidence of statements made by Ms. Richins and actions taken by Ms. Richins after February 14th, it is not that action. That is the alleged successful completion of the attempt. Rather, the actions and statements the court is considering that occurred after February 14 are her text messages to her paramour to the effect of, "I wish he would just go away," or "if my husband would just go away." Her contact with her source of controlled substances, seeking something stronger, which leads to a reasonable inference that the stuff she got before did not give her the results she wanted. And her statements on June 18, 2022 to her best friend that she provided a lunch. And this, of course, includes the evidence from the morning of February 14 that she did, in fact, buy food from the Mirror Lake Diner. Taken together, viewed in the evidence in the light most reasonable to the state, drawing all reasonable inferences in the state's favor, this evidence supports a non-speculative inference that Ms. Richins attempted to murder her husband with fentanyl on February 14. Having drawn that determination, it also requires the court to bind her over for trial on count 4, which is the distribution charge related to February 14.
Because they're saying she gave it to him. That's
Pause
distribution.
there before we get to the financial charges. Mr. Bloodworth, do you need any clarification of the court's ruling so far?
So 1, 2, 3, and 4 are all bound over.
Ms. Lewis?
No.
Okay. All right. Count 6 and 7, mortgage fraud with respect to the Iron Bridge loan and the Boomerang Finance loan, respectively, are bound over. Counts 7 and 8, insurance fraud with respect to the $250,000 True Stage policy, and then a scheme with respect to the $100,000 True Stage life insurance policy, respectively, are bound over.
Those are the fraudulent insurance claims. You said them wrong. It should have been 5 or 6, 7 and 8.
I think you just said 6 and 7 and 7 and 8, and you skipped 5.
My apologies. 5 and 6 are Iron Bridge and Boomerang, respectively. 7 and 8 are the $250,000 True Stage policy, and the scheme related to the $100,000 True Stage policy, respectively.
So now 8 charges.
9, 10, and 11 are forgery counts related to the altered America First Credit Union account statement submitted in respect to the Iron Bridge and Boomerang Finance loans, and with number 11, the forged signature on the $100,000 True Stage life insurance application. Mr. Bloodworth, any clarification?
No, sir. Thank you.
Ms.
So
Nestor?
every count moving forward to trial.
Okay. Let's pause there for a second. Ms. Nestor, Ms. Lewis, I imagine Ms. Richins would like to enter pleas of not guilty to all charges.
Correct, Your Honor.
Does she waive reading of the third amended information?
We waive reading.
All right. The court, Ms. Richins, is entering pleas of not guilty to counts 1 through 11 in the third amended information. Where would you like to go from here?
We'd like to set a trial date, Your Honor.
Have you had a reasonably detailed conversation with the state about numbers of witnesses, length of time, because I'm going to have some questions.
We have discussed it, and what we have agreed to, I don't know if it works with the court calendar, is we would like to set aside 4 weeks, basically the month of May.
4 weeks, the month of May. That's what you have to go for first.
We think that would include jury selection. So we figure the jury selection is going to be at least a week and 3 weeks for trial.
Trail TV, reach out to me. I've got a way to get you the raw files if you want them.
Have you given any thought to pre-trial motion practice?
Just need your email.
We have
Discussions regarding jury selection. There's going to be some questions regarding preserving the integrity of the jury selection process.
Correct. We've discussed it. We haven't set particular dates for motions, although I believe we thought it would be two rounds of pretrial briefing and motions, and we need to do scheduling, or we need to do a scheduling order on those motions and briefs.
Can we start having those conversations regarding pretrial deadlines, maybe a pretrial conference in mid-September?
Next month?
Yes. We're in trial until September 20th, though, so actually if we could just do
late
it
September.
After that.
Does that make sense, Mr. Glover?
Yes, sir.
Okay, give me just a moment.
So now we begin a little circus of trying to find a date that works for everybody. And we go back and forth on this one. It takes a while to get a date here. At the end of this, we're going to have a date. It's not too far off from what they originally proposed, which is the month of May. But Judge tries and tries, and his schedule is booked solid on all the dates he's available that he wants to have it on, or the dates that he's available. The defense is either in trial or has another thing going on, and so at the end, we'll see how he settles this
Counsel, I
up.
have a couple of questions here. If you're not prepared to answer these, we can continue this discussion. But first, rather than the entire month of May, can we just say the last week of April, the first 3 weeks of May?
We were a little bit worried because I think Easter's really late this year, and
Memorial Day is included in the dates. So I mean, you're frying pan into the fire. More to the point, my signing week is the last week of May on Memorial Day. It could be tough for me to trade out of that.
I think we checked we were trying to avoid spring break.
Excuse me. Hold on a second. I'm in the wrong. Let's try this again. My apologies. Oh, it is there again. Did I get Memorial Day twice? Is that possible? Hold on a second.
He keeps getting the bad schedule as a judge.
I did. We'll review who I pissed off to get that. With two questions. One, that will be hard to trade out of. Two, I need my Fridays.
Right.
So no court on Fridays.
I think we took that into consideration when we decided we thought it would take 3 weeks.
Okay.
For counting jury selection. The only concern we had was about Easter week, that people traveled, and we were trying to avoid losing jurors who might travel over Easter. So that's why we started. I'd almost rather push it to the first week of June and take that day. Is it a week that you do that, whatever it is? Oh, I don't know what that is.
So Easter in 2025 is April 20th. I think we're going to be okay.
Okay, then we could do the last week of April.
So what I'm asking, is
that would work.
April 28th through May 22.
Right.
Not including Fridays.
Right.
The idea being that jury selection would be April 28th through May 1.
So a week of jury selection, and then 3 weeks of trial. Right?
Say it again. Yeah. So then let's talk. I'm going to have lots of questions about how we're going to do this.
now it gets hairy. This is where it starts getting messy with the prelim hearings, or the
We're going to have to
pretrial hearings.
We'll have a discussion about whether we're doing half days each of those days for jury selection, whether we're going to ask jurors to be available the whole day each of those days, whether we'll need to have a discussion about whether we're doing 4 veneries, 1 for each day.
Right, I do anticipate, Your Honor, there will be a lot of individual voir dire based on the,
I imagine. And so we'll want to be thoughtful about how many we ask to come each day.
Right.
I'll need to reserve sufficient resources in terms of people power and jury selection slots. Third district policy is we do this using the virtual jury selection system. You're going to have to file a motion and cite extraordinary circumstances, and it's not my decision. Okay. We can have that discussion too.
You want to block that each day for right now?
Yeah.
So right now, we need to take the 9:30 slot each day.
That's fine. Block it for now. We'll have a discussion. What's that? Just say each day.
He's talking to his clerk.
We can change the numbers later.
His assistant.
Brittany, what do we have going on in the afternoon of September 27th?
Prelims.
Prelims on September 27th in the afternoon. That basically puts it a month out to the first meeting.
3 p.m. Yeah.
We set 1 3 p.m.
Everyone's huddled around their calendars trying to find a date that works. Kouri's available all the time. This gentleman has the longest tie on planet Earth.
Counsel, are you available on the morning of the 26th? Or the 26th before, say, 2 p.m.?
I may be in a trial. Would it be all right if I can't make it, if Miss... Are you trying to use?
We might both be in trial.
There's a chance we could be in trial that day. A chance. It's set for a 3-day trial. I'm sorry. It's set for 3 days, and I think it's only going to take 2. It's a trial down in Salt Lake. So we could just tentatively set it if we need us to.
Well,
In the afternoon, better, in case we kept waiting on a jury or something.
all right, let's avoid that day. 27th is bad.
A few hours later. Judge wants to get this done quickly. You know, get this first pretrial
Do it
meeting.
remotely. We could definitely on the 26th.
In the morning or the afternoon?
In the afternoon would be better. I'm sure the judge would give us, if we need to step out and do take a break.
I've already moved the hearing once, I'm sorry. I can't do it in the afternoon.
Okay.
Bear with me.
I believe her family.
I'm sure this is like nails on a chalkboard to all of you. I apologize.
Her family can bring her clothes through the jail and her lawyers.
We said something at 3 on the 26th.
We did. It's a theft.
This could have been an email very easily.
What do we have at 1:30?
I don't know why the recorder gets the porta desk. She has such an important job transcribing everything. Using the funny little typewriter. Look at that sharp focus.
All right, that's a mess. Let's not do that.
Andy City. That's not going to happen. Not with Kouri. She has a lot of family there. Her mom was there yesterday. I think she was there today. His family's there as well, so lots of family representation on both sides. Judge is good at a lot of things. Scheduling, not one of them.
Oh, goodness. Okay. Yeah. All right. Counsel, the morning of October 22? Nah, can't do that. I'm sorry. My goodness. This is the problem. I'm going to have to push something out of the way. Ms. Richins, I apologize. I'm thinking about this the wrong way. Ms. Lewis, Ms. Nestor, I think we need to hold an initial pretrial conference to start talking through pretrial deadlines and start talking about jury selection. Tell me when you'd like to do it. I will make room.
That's awesome. This judge apologizes to Kouri Richins, says, I'm sorry, I'm doing this wrong. You tell me when you're available. It needs to happen. This is your time. You're the one sitting in jail.
September, Monday.
I would unfortunately be out of state.
He says, I'll make room.
That whole week.
But that week
That
I
I can't fix.
What about October? It's not this whole week.
Corey's the one in on the screen right here. She's got the shirt that matches mine with the black suit coat.
What about the afternoon of the 23rd?
Later.
Of
September.
September
23rd, later afternoon, like 3.
We'll make it work.
Okay, so next.
Would you like that to be in person or by WebEx?
Whatever you prefer, will probably come up.
I prefer in person. Is 3 p.m. workable?
Yes.
Okay. Mr. Glover?
Yes, sir.
All right. We'll set a pretrial conference for September 23.
September
At 3
23rd,
p.m.
3 p.m. Mountain Time is the next time Corey's going to be in court. Could be a very brief hearing, like
person.
half an hour to an hour.
Counsel, I need you to start talking to each other about
I got
issues
the
to
memo.
anticipate, pretrial deadlines. I won't be able to see around every corner. I would appreciate your input, given your experience on how you'd like to conduct this. We need to start talking about jury selection. To the extent I'm going to have to ask for special treatment, favors, or to the extent you want to file motions to try and secure an exception from the standard practice in the 3rd District, we need to get rolling. I would prefer that you have notice of how you're going to be picking the jury in this case as early as possible. Okay.
So it
Mr.
sounds like
Glover, anything?
they want to do something a little different with how they pick the jury.
Ms. Lewis.
So we'll probably hear more about that in the pretrial.
Mr. Ramos.
Nothing, Judge. Thank you.
Ms. Richins, I'll see you again on September 23 at 3 p.m. I wish you the best of luck. Court's in recess. Thank you.
And with that, we are done with the hearing that was supposed to take 3 days and ended up only taking 2. So there we go with that one. I will say, if I know a lot of you use the stream I put up, there is a better quality file, the one I just played, that I can make available to you through email. I can send you. I'm talking to other channels that want to use this if they want to use it or get clips or something without trying to record and degrade it, lower the quality a little bit. I can send you that via email through WeTransfer. I've got a WeTransfer account. I can post it. I can move like 2 terabytes a month or something. I've got plenty of space for that, and it doesn't cost you anything. So reach out to me if you're one of those who would like to use that. As always, no cost. I will say, going forward, I'm looking at how to expand this a little bit to get better access to some of the other courts we want to follow. And I've got some ideas on numbers, and I wanted to share these just so you guys know where cost is. So I have equipment that I'm prepared to send out to contacts. First of all, I need to have a contact in every place that we are sending somebody to be in the pool. So we have to file the paperwork, which usually is free. We have to send somebody out there. Going rate for sending somebody to a trial like this is right around $200 a day for their fee plus mileage. and it's like the standard IRS mileage. I don't know what it is, 34, 38 cents a mile or something like that. So the further they drive, the more it costs per day. And of course, you get that twice. But Greener says, I'll cover the Caribbean. Nice. Thank you, Greeners. I've got you down for that. Just as soon as we have the trial in that area, we'll do that. So what I'm looking at is getting a couple more Stream Decks, and probably using WeTransfer and having people record the show and then upload it, and then we'd have a high quality version like we have right here, where our video is higher quality than what most people put out. We do that because I like higher quality video. I don't know. I know it's cheaper to post 720 video. It doesn't require as much bandwidth to push a 720p video than as it costs, as it uses to take a 1080. And I like the 1080. It makes me feel like I'm there watching it in person instead of like squinting at a blurry TV. But so we're looking at doing that. I've got some contacts already in a few areas that can help out, but I need to expand that a little bit. Obviously, I'm looking at getting more people in different areas. The system I want to have you do, if you're one of the people that helps me out, would be pretty straightforward and simple. It doesn't require any of the advanced knowledge that I have to set up my way over engineered channel. It's basically a plug in, twist, push the red button. That's basically how it works, and then upload a file at the end of the day. But anyway, that's where we're going that way. So I'm excited to have taken some steps forward in that area as well, so we can get into some more courtrooms. Amazing day in court. It was really, really good. I have to say the entire media pool was a blast to hang out with here at this trial. A few of the people I knew from, or I knew, we had joint contacts. So we both knew the same people because I worked at certain stations years ago and they also worked with the same people that I worked with. But I didn't work directly with any of them, although except for the AP photographer. I've been at sporting events. I've been the video guy when he was the still photographer at some sporting events. But that was cool. It's definitely 1099 Greeners. It's 1099 for sure. But Braxton, on the life-size 10X LFZ, I don't even know what that is. The 10X, it sounds like a camera with a 10X. Is it a PTZ? I'd have to look that one up. Anything that works you save from being thrown away, I think is great. All right. Any questions about this hearing or about anything else? I tell you, going to work up in Park City for the past 2 days, beautiful, amazing drive. Headed up the mountains, just unbelievable, just gorgeous, gorgeous, gorgeous. You can't have a better environment as far as scenery goes than that. It was so much fun. It's basically a PTZ. Yeah, I'd say it's cool. It really is going to depend what sort of outputs it has, Braxton. Like whether it's HDMI, SDI, USB, things like that. That's going to really limit how you can use it in the setup. But Kiki's Garden, I'll cover Arizona. Yeah, we'll try to build this network out. I probably need to get some help to do that as well. Next Richins date, I think it's a very brief hearing, right? I think it's scheduled for 3 p.m. on September 23rd. 23rd, 26th, September 23rd. So first of all, with it starting at 3 p.m., it's not going to go late. It's probably just going to be a brief hearing where it's like, here's a couple issues. Okay, we'll talk about those later. You guys work it out. That's about all. What was it like in the media room? Are you watching on screen? Special K. This is the funny thing. The media room we were in is actually the jury deliberation room. So there's no televisions on the walls. There's no anything. We just run a cable in under the door and then they close the door. So we can't even see the courtroom at all. I've never even stepped foot in that courtroom the entire time. Occasionally I was able to glance in when the doors open, but that's about it. We're sitting at basically a conference table, and on the floor there's there's plugs everywhere for power, and we plug everything in, and then everyone just takes all their live view devices, which is a bonded cellular encoder, and they're big backpacks, and they just set them on the table, and then everyone connects little splitters. They take the signal that comes in from the cameraman in the courtroom, and they connect it to a splitter, so it's like 1 in and like 8 out. We had 2 of those, so it was like 16 different outputs, and everyone just connects to an output, and then everyone can see and record separately. A couple people showed up late, and for those people, the pool photographers were required to give them a copy of everything, which sort of sucks because they have to sit around and wait, and it takes like 25 minutes to copy a day's video. But just sit around, and everyone's just talking. Mostly the news people talk amongst themselves about job opportunities in other markets. This is something that the news reporters and cameramen are constantly looking at. The business is, you don't stay in the same place very long, especially if you're good. You move around, you try to move to a bigger market, because that's where the money is. So that's what the news people talk about, and they're all friendly. I realize that, news channels are like, we're fighting for the same audience, right? We cover the same market area. We're in the same media market, and, if somebody's watching my channel, they're not watching yours. But they get along so well, and they're all just like, they're chummy, and people are like, hey, you want me to go get lunch? It's really fun to see, because in a lot of businesses you wouldn't see that, but the news market, that one day I'm working for, say for instance, Fox 13. Tomorrow I might be working for KSL Channel 5, and all these people that I've been working with or against are now my coworkers. So you always have to sort of treat the other media as future potential coworkers, and I think that keeps the relationships pretty good. And there's not really a lot of egos there. Everyone's in it the same, so not huge egos there. Pickles and Zoe the cat. I didn't see your comment. Let me scroll up. When it comes to the like Court TV and Law and Crime, unless it is a big trial where Court TV is sending out like one of their trucks, or Law and Crime is sending out a crew to run the cameras. Generally, they hire local freelancers, and they just send them the equipment to plug into. So they'll send them either the live view, or they'll send them a recorder, or both, or something, and they just plug in, and you make the call and say, okay, this is Scott. I'm in Park City at the Kouri Richins trial, checking in. I pushed the record button. Do you see a feed? And they're like, yep. I'm like, all right, and it's done. And they just sit there and watch the equipment. And those individuals are usually a little quieter, but we had a blast just hanging out and talking. Let's see, Pickles and Zoe, what did you say here? I'm scrolling up, looking. Have good news. My daughter had her baby. Awesome. Pickles and Zoe, that is awesome. Congratulations. Grandma, that's awesome. Let's see. CBD, thank you. I have to say that the cost of sending somebody to an area is going to require me to have a lot of people in a lot of different areas. It would be very difficult for me to cover. There isn't that much money in it. Does that make sense? There isn't that much money in live streaming to be able to send somebody, from Washington down to California. When you start adding the fuel cost, and if you're driving that far, there would be like per diem and all that. That would be difficult. But if somebody was local, or in a local area, that makes a little more sense. Let's see. EDB shouted you out today and expressed super gratitude on your hard work. She is amazing. She came in here right on the beginning of the live stream and gifted 50 memberships as a thank you. I have always been impressed with Emily. I love the energy she brings and the knowledge and experience she has from her legal background. Going back to days in California. It's so much fun. I love what she does. I think her channel is not just informative, but it's also very helpful to me to look at how it can be done right. So she has so many things that she brought to her channel that really have changed the way I think all of LawTube operates. But super shout out to her. Thanks again. That's very generous of her. I think honestly I've said this many times. There are a lot of us, and we're like the news stations. If somebody's watching us, they're generally not watching the other person. But the fact that there are a lot of different opinions, a lot of different perspectives and personalities that can give you commentary about a trial, I think it makes all of LawTube and LawTube adjacent community better when there are a lot of options. If there were only like 3 or 4 to choose from, that would sort of suck. for you guys, because you'd have to listen to me like 25% of the time, and that's no good. So super excited. There are lots of options. Sometimes you watch a trail there, sometimes you watch it here, and I think that makes everything better. So yeah, she brings the energy for sure. Plus, I think she's like the coolest mom on YouTube. Let's see. All right, let's see. What's the plan tomorrow? Well, we're not going back to Kouri Richins. That's done. Even though they slated for 3 days, they only took 2. So I'm going to take the rental car back. Actually, I think I'm headed down to. I think I'm leaving in just a minute. Take my son to an exercise place tonight, and then I'll take the rental car back, and then it's back to regular court watching tomorrow. So we might have some, I guess, verdict watch in the Telus trial. That's crazy. We might. I have not seen the closing statements yet. Closing arguments. I'd like to catch up on those. I haven't been following Wade Wilson. What's been happening on the sentencing on that front. So I've got a little catch up to do, but we'll probably do some court hopping. I think the next big case that's on the schedule, if I remember correctly, because I have not looked, is possibly Carly Gregg out of Mississippi, the 14-year-old accused of murder, charged as an adult with cameras in the courtroom. There was something in Thurston County. We might watch that. Didn't see anything about Jamie Knoll. I don't even know who Jamie Knoll is. Is that terrible? Wade Wilson got the DP. Okay, so that's not a surprise to me. That isn't, with the type of crimes he committed just on a whim. But let's see. Wait, I'm on YouTube. Mrs. R.A., hello, welcome. It's nice to see you again. I have to give a shout out to Peter Tragos as well. He's covered this hearing as well. I think he was actually covering the end of this hearing right when we started. And great insight from him as well. Love the lawyer, and his fabulous hair. I am jealous. All right. Noel just pled to 27 counts. Boom. Oh, was he the sheriff? Is he the sheriff that was accused of some doing things not quite? Yeah, the former sheriff. He and his family indicted. Indiana, I think. Yes. If he pled guilty, so basically he pleads guilty, there's going to be no trial. But yeah, he's going to be in the slammer for a long time. I think there's some discussion on some difference of opinion in how long he might serve because of the way the law is written in the state about concurrent or consecutive sentences, and it might mean that his sentence is actually much shorter or much longer. It could mean a drastic difference in his sentencing based on how the law is interpreted. So that, I think, is the next thing that happens there. I have not been fishing yet. I need to go fishing. I drove by a lot of real cool places to fish today. I've not seen the Wade Wilson sentencing. CBD, look for the message about Peter Tragos. I'm looking. The chat's going fast here. Let's see, hung with Brandy all day. Okay, Peter shouted you out as well. He used a bit of EBD's feed from you. Excellent. Said he wished he had access to that earlier. Send him an email. And again, thank you for, yeah, I love it. I want to continue doing this, and I think really, I think it's probably going to make me a target, quite honestly. But uniting sort of as content creators to do this, I think is the best solution for all of us. But I think it makes a better product for y'all. That's what I think. RA is a good way. Oh, I just realized that I owe Miss RA flowers because I said EDB was the coolest mom on YouTube, and that's when the comment was, "Hey, I'm on YouTube." So now I have to tell Emily that I was completely mistaken when I stated that she was the coolest mom on YouTube, because my wife is the coolest mom on YouTube. So. Sorry about that, Emily. I didn't mean to get your hopes up and then dash them like I did. But facts be facts. That's all I can say. Yes, I'm sorry, Mrs. R.A. Please forgive me. All right, I need to end for today and order some flowers. How comfy is the sofa? Now I'm about to find out, Bug Dugger. No, I've never had to sleep on this sofa. I've never been kicked out. She's amazing. All right. Oh man, I stepped in at that time, and it's all my fault. I apologize. Hey guys, it's been so much fun. Thank you very much for your patience as I've been working out sort of away and not live streaming. Thank you. It's good to be back. I look forward to tomorrow, where we sort of get back into the regular stream of things as we get ready for our next big trial, or hopefully, fingers crossed here, a tell-us verdict tomorrow. That would be neat. So we'll see how that goes. Tonight when you go home, please hug the people you love, smile at someone to make their day just a little bit better, and please stay safe till we go live again tomorrow morning. Doing a little bit of court hopping tomorrow. I'm hoping for something really fun from Judge Cedric. Maybe a little action out of Thurston, Washington. And a verdict. Is that too much to ask, those three things? All right. You guys have a good one. Enjoy what's left of the day. I'm gonna head out, take my son out to a little trip. So, all right, you guys be good to each other. We'll see you in the morning. Have a good one. Bye.